Judgment in the appeal Imperial Tobacco Limited against the Lord Advocate.
Lord Hope will give the judgment.
This is an appeal about the limits to the legislative competence of the Scottish Parliament. They are set out in the Scotland Act 1998. The question is whether sections 1 and 9 of the Tobacco and Primary Medical Services Scotland Act 2010 are not law because they are outside that legislative competence. Section 1 of the 2010 Act prohibits the display of tobacco products in a place where tobacco products are offered for sale. Section 9 prohibits vending machines for the sale of tobacco products. The appellant's first broad argument is that by reference to their purpose, sections 1 and 9 relate to the sale and supply of goods to consumers and to product safety. These are matters which are reserved to the UK Parliament under the 1998 Act and on which the Scottish Parliament cannot legislate. Their second broad argument is that sections 1 and 9 modify the law on reserved matters. They say that two sets of regulations, the Tobacco for Oral Use Safety Regulations 1992 and the Tobacco Products Manufacture, Presentation and Sale Safety Regulations 2002, should be treated as being part of the law on reserved matters because their subject matter relates to the sale and supply of goods to customers. As those regulations contain rules of Scots criminal law which are special to a reserved matter, it is contended that sections 1 and 9 modify those rules, which under the 1998 Act they cannot do. The appellant's third argument is that sections 1 and 9 create new offences in addition to those already provided for in the regulations, which can only be committed in the course of the sale and supply of goods to consumers. At first instance, the Court of Session held that none of the appellant's challenges to the legislative competence of sections 1 and 9 were well-founded, and it dismissed their petition for judicial review. Their appeal to the Inner House of the Court of Session was unsuccessful. They have now appealed to the Supreme Court. For the following reasons, this court unanimously dismisses the appeal. First, the sale and supply of goods and services to consumers is a reserved matter. It encompasses all aspects of regulation of the sale and supply of goods and services to consumers within the field of consumer protection. But the purpose of Section 1 is to enable the Scottish ministers to take steps which might render tobacco products less visible to potential consumers and thereby achieve a reduction in sales and thus in smoking. The purpose of Section 9 is to make cigarettes less readily available, particularly, although not only, to children and young people with a view to reducing smoking. The Court does not see how it can be said that the purpose of these sections has anything to do with consumer protection. Their aim is to discourage or eliminate sales of tobacco products. They do not seek to regulate how any sales that may take place are to be conducted or to protect the consumer from unfair trade practices. Second, product safety too is a reserved matter. But the purpose of sections 1 and 9 has nothing to do with the standards of safety to be observed in the production and sale of tobacco products. The sections are designed to promote public health by reducing the attractiveness and availability of tobacco products, not to prohibit their sale to those who wish and are old enough to purchase them. Product safety directs attention to matters that are of concern to the single market within the UK in the general area of trade and industry, but it is not the purpose of sections 1 and 9 to disrupt or unbalance trading in tobacco products in that way at all. Third, sections 1 and 9 do not seek to amend or otherwise affect anything that is set out in the two sets of regulations. In that sense, they cannot be said to modify them. The purpose of the offences that they create is to discourage or eliminate the sale or supply of tobacco products. If this purpose is realised, that will be their effect. This is plain in the case of vending machines, because the effect of Section 9 is to prohibit the sale of tobacco products by way of vending machines. The Court can see no connection between the purpose of Section 1 and the law on reserved matters. The criminal law relating to any sales that may take place where tobacco products are available for sale will not be affected by Section 1. Section 1 does not create a new offence in regard to any such sales, and the existing offences are not modified. The Court therefore holds that Sections 1 and 9 of the 2010 Act are not outside the legislative competence of the Scottish Parliament.
The court is now adjourned.